This week, search warrants unsealed in the First State murder put the focus on a confidential police informant. According to the warrants, the informant claimed Maxwell Anderson revealed a plan to kill and dismember Shade Robinson before the two went on a date in April. 12 News legal analyst and criminal defense attorney Dan Adams is here with us this afternoon to talk about this. Let's talk about confidential police informants. How often are they used? And we noticed in this particular warrant, police said they were familiar with this person and had used this person before. How often of a practice is that?
Yeah, so confidential informants are one of the biggest tools in law enforcement's toolbox. Again, you're having somebody who knows something because they're in the streets, they're talking with people, and for their own reasons, often to work off their own case or sometimes even for money, they'll come forward and provide that information. Other times they're just trying to be good citizens, of course. But in this case, having a repeat person who law enforcement knows that they've represented, have helped bring felony cases in the past, that's not unusual. It is unusual for a case like this, given just how unusual the homicide was. To have a confidential informant say, hey, this person admitted to me that they had a plan beforehand to commit this type of crime, totally unusual.
To that point, knowing about this potential plan beforehand, is there any legal liability for this informant to come forward to alert police to this potential murderous plan?
Well, one, you have to assume that it's true, right? There's a few items in the warrant resuscitating the person's discussion to the police officer, which give me a little pause as to the veracity of what this person was saying. But if this person knew that there was a plan to commit murder and did not alert law enforcement for it, yes, certainly there's some culpability for them as well.
And the use of this confidential informant getting criticism from two attorneys for Shade Robinson's family as well as attorney for Maxwell Anderson, particularly criticizing the fact that this person has anonymity. Do defense teams have a legal right to learn the identities of police informants?
Not up front. There's some barriers to get through, but it's not uncommon for the prosecution to hold back the identity of an informant. In fact, there's a lot of public policy reasons why you would not want to expose who that person is. Now, if the prosecution wants to bring that person into court, obviously we're going to learn who that person was. Now, what's really interesting about this case is the police were in that house 2 times already, and the informant 2 weeks later said, hey, you have to look in the basement, and they used his statement to go back in a 3rd time.
And that's something that gives you pause?
Well, certainly. A big hole in this case for the prosecution is there doesn't seem to be any remnants of this dismemberment. You can think how gory and awful this would have been, and there would have been blood and other matter from the victim in the house, and so far as we know, there's been none found.
All right, want to pivot to another high-profile homicide investigation. That's the hotel death homicide. We had 4 suspects charged. None of them were in custody originally. Kind of walk us through how it works to get those people into custody and in front of a judge. Do they work things out with their lawyers and prosecutors?
So a warrant is a warrant. So if you have an open warrant for you, law enforcement can, if they know where you are, they can come and pick you up. And so if you know that there's a warrant out for you, the best practice is to go to the courthouse and announce yourself. Hey, I'm here, I know there's a warrant. They'll take you into custody. Now, if you have a defense attorney, oftentimes you can call the out of custody intake court, and they can arrange to have that case brought up, and you can be heard on bail right then. And the best thing to do is to do that so that the court knows you're not trying to flee, you're not trying to avoid the case. You know that there's a case, you know you have to have bond set, and that's your strongest argument.
That could work in a defendant's favor by turning themselves in.
Definitely.
All right.